Is that so that's how because
Welcome everyone to our webinar, which is titled the Vetting of the Employees and the Nrso. It's not only the employees, but I think that the title is narrowed. It's broader than the employees. As you know that the Criminal Law, Sexual Offences and Related Matters Amendment Act of 2021 introduced certain amendments that increased then the scope of the persons that must be vetted, and the failure not to vet is criminalized by this act. So it's very, very, very important that we know exactly as to who are these people who must be vetted. And also, we also have, and this act, the commencement date for its implementation is the 31st of July, 2022, meaning that it's already in operation. And also the Criminal and Related Matters Amendment Act of 2021 also expands the scope of the intermediary services in the country to civil proceedings and also to matters that relate to older persons. So these are the issues that we need to know, and so that we don't find ourselves in spaces where we have to be charged for failure to have ourselves vetted against the Nrso at the service points that are exposing us to vulnerable persons as defined by this act. My name is Advocate Praise Kambula, and I will be the moderator for today, and the person who will be facilitating this session, giving us this presentation, is Ms. Dombi, who is she is the National Registrar for Sex Offenders in the Department of Justice. So I will be handing over to her to give us the presentation. Ms. Makila, over to you. Whilst she is preparing to flag her presentation, may I request that we put off our cameras and switch off the audios so that we do not get disturbed. And we will also be giving you an opportunity to ask questions, the Viva Voce questions, and you can also reflect your questions on the chat box, and we will be considering those questions after the presentation. Thank you. Over to you, Ms. Makila.
Thank you, Advocate Kambula. Am I audible?
Yes, you are.
Is the presentation on the screen?
Yes, if you can just place it on presentation mode. Thank you.
Okay. Thank you very much. I'm just trying to do the slideshow now. I hope it is all there. Thank you very much, Advocate Kambula. Good afternoon, colleagues. As indicated or introduced.
Sorry, it is not yet on the
Okay.
slide.
Is it now?
No.
I can see it. Sorry,
Okay.
Ms. Khan.
Yes, but if you can just put it on the presentation mode. Yes, thank you.
It's now showing.
Yes, yeah, thank you.
Thank you very much. Thank you very much, Advocate Kambula. As introduced, my name is Domzotwa Machila, and I am the Registrar of the National Register for Sex Offenders. Today, as the topic indicates, we are going to be looking at what the National Register for Sex Offenders entail. What are the obligations of the employer? What are the obligations of the employee? And what is it that is required of one to actually be vetted against the National Register for Sex Offenders? We'll also zoom in into what the new amendment has actually come up with. As you may be aware, I need to give you what the Criminal Law Sexual Offences and Related Matters Amendment Act, the Principal Act, entails so that you can have the appreciation of what has actually changed in the new amendment. The whole Principal Act is aimed or was aimed at protecting the rights of the vulnerable persons. In particular, in this instance, when we're talking about the vulnerable persons, our focus was only based on the children and persons who've got mental disabilities, the society as a whole and the economy. So it further states that sexual offenses are primarily a social phenomenon which is reflective of deep-seated systemic dysfunctionality in our society. And that legal mechanism to address the social phenomenon, even if it is limited and reactive, it is nonetheless necessary. When they're saying it is reactive, we were actually looking into the position at which we are based as the Department of Social Development, as the Department of Justice and Constitutional
sorry
Development.
to interject. Is it possible for you to switch on your camera?
Oh, my camera, okay.
Yeah.
Let me. Okay.
There's a hand that keeps on coming through. Is Dr. Tebe. Dr. Tebe, is it urgent, your question right now? Because we would like to take the questions after the presentation. All right, Ndombi, you can go on. Thank you.
I'm not sure if my camera is on there. I've tried to switch it on.
Yes, it is. Thank you.
Okay. Yeah, like I was saying, that the although the legal mechanism which is aimed at addressing the social phenomenon is limited and reactive in nature, what I was saying is that it looks at where we are based as the Department of Justice. In actual fact, because we are not positioned at a place where we investigate, where we prosecute, where we actually adjudicate the cases, but it looks at us as the repository of all those sexual offenses convictions, wherein the court will actually give out those convictions, and then we as the registrar's office will then have a repository where we actually record those database, which we then call a National Register for Sex Offenders. Next slide. Now, the enactment of the 2007 Act, it demonstrates quite clearly the intentionality of the legislature with being specific in the protection of children and persons with mental disabilities, which is why the Nrso was created accordingly. So on the other hand, you will have Section 2G of the Act, which states the objects of the Act, which says that is to afford the complainants of sexual offenses the maximum and the least traumatizing protection that the law can provide, to introduce measures which seek to enable the relevant organs of state to give full effect to the provisions of the Act and to combat and ultimately eradicate the relatively high incidences of sexual offenses committed in the Republic with the establishing of the National Register for Sex Offenders. So it is in this light where you will find that Section 42 of the Act creates an obligation on the Minister of Justice and Correctional Services to establish the register and designate a fit and proper person as the registrar of the National Register for Sex Offenders. This is where it provides what the registrar must do to perform and exercise his or her powers, duties, and functions, subject to the chapter, which is Chapter 6 and its regulations. So the purpose of the Act, as I have alluded when I started, amongst others, it stated as being to enact a comprehensive provisions which deal with the creation of certain new, when it says certain new expanded or amended sexual offenses, you will recall, colleagues, that when the National Register for Sex Offenders, or when the Principal Act was enacted, it sought to augment or extend the scope of what we knew to be defined as the crime of rape. Rape, you will recall that it was penis, it was vagina, it was unlawfulness, it was lack of consent and stuff like that. But it did not take into account other forms of sexual offenses which could be perpetuated against an individual, elsewhere, by anything else other than a penis, other than a vagina. So it expanded the definition of rape so as to include other sexual offenses, like your fleshing, like your compelled sexual assault, and so on and so forth. So with the aims to address the particular vulnerability, the reason why the focus was only on children and persons with mental disabilities, it was because they have been the most vulnerable of them all in the society in respect of sexual abuse or exploitation. So the functions of the Nrso basically include the prevention of repeat offending by inclusion of persons who are found guilty of sexual offenses against children and persons with mental disabilities in the Nrso. So in terms of Section 50 of the Act, this is where we were capturing, or where we had actually received what now we call the register. We have received the information from the South African Police Services. We have received information from the Department of Correctional Services, but we were also supposed to have received the information from the Department of Health. However, because it was not a legislative prerogative at the time when the Department of Health was collecting that information, for them to keep that information elsewhere, for them to be able to provide us with same when we were establishing the register. So the two organs of state that were able to provide us with historic conviction was the Department of Correctional Services, as well as the South African Police Services, with regard to all convictions that were done prior to the establishment of the register or the implementation of the 2007 Act. Another function is to prevent persons who were previously convicted of sexual offenses against these two categories of persons from working with or be placed in circumstances where they will gain access to them. So this we do by issuing the certificates in respect of particulars, because you will note that Section 51 prohibits the employment or holding of any position which will place this person in any position of authority, supervision, or care of a child or a person with mental disability. It further prohibits the granting of licenses to manage or operate any entity, business concern, or trade in relation to the supervision over or care of a child or a person with mental disabilities. It also prohibits that we grant convicted sex offenders from becoming foster care parent, kingship care givers, temporary safe caregivers, or adoptive parents of children, or being curators of persons with mental disabilities. So this establishment of the register is provided for in terms of Chapter 6 of the Criminal Law, Sexual Offences of the Principal Act. So these, all in all or summarily, it aims only to regulate the management and the administration of the National Register for Sex Offenders. So in short, it requires that the particulars of anyone found guilty of committing a sexual offense, they must be recorded in the National Register for Sex Offenders. It also prohibits this, I've mentioned, the aforementioned, from being placed in a place where it places them under circumstances where they have access to them. So relevant employers, those that are employing people who actually work with children, they are required to vet existing employees and potential employees against the National Register for Sex Offenders in order to determine whether they are suitable to work with them. So how then Chapter 6 of the Act was composed is that you will have Section 40, where you will have all the definitions included in there, where it will tell you who is a child, it will tell you who's an employer, it will tell you who is a relevant authority, and so on and so forth. And Section 41 is the one wherein, if you are a police official, if you want to arrest someone who is violating the provisions of this particular act, you will then arrest them for violating the provisions of Section 41, because this is where the prohibition of certain types of employment of certain persons who have committed sexual, you will find it on Section 41. Section 42 is the one that deals with the establishment of the register and the designation of the register. And then 43 are the objects of the register. 44, this is say who is actually entitled to apply for a certificate. 45, these are the obligations of the employers in respect of who they employ, their employees. Section 46 are the obligations of the employees. And 47 The obligations in respect of license applications, 48, obligations in respect of those that seek to apply for fostering, kinship caregiving, temporary safe caregiving, and adopting children and or applying for curatorship accordingly. 49, it tells you what are the contents of the register, what the register contains. And section 50 is the one that actually outlines who can actually be included in the register. So this person, it will then outline what type of a sexual offense has this person committed, which court has actually given that order, at what date was the trial carried out or the conviction carried out, when was the sentence carried out, was the victim a child or a vulnerable person or a person who is with mental disabilities, and so on and so forth. And section 51 is the one that outlines now who then qualifies to be removed from the register. Section 52 mainly deals with the confidentiality and disclosure of information, the basis upon which one can disclose information that is in the register. Here, this is where it says the circumstances under which you can say the particulars of A are included in the National Register for Sex Offenders or not, and who then qualifies to can apply in a prescribed format to check who the the details of whoever that they want to check in the register. So section 43 deals with the regulations which pertains to the register, and 54 is the one that outlines the obligation to report commission of sexual offenses against children or persons who are mentally disabled. But 54 again is the one which is amended, where we will get into what has been amended on 54. 54, the original 54 will tell you that anyone who is aware that a sexual offense is being committed against a child or someone who has mental disabilities must report that to the police. This is how it was in the Principal Act. I will soon outline what has been amended in the new amendment. Now, when we look or when we zoom into persons who are entitled to apply for a certificate, you will recall that I said that the certificate, it is only obtainable in a prescribed manner, which means an application for a prescribed certificate stating whether or not the particulars of a person mentioned in the application are recorded in the register may solely, for the purpose of complying with any obligation in this chapter, be made in a prescribed manner. It means this is provided for in regulation. So you will have the forms that one will use, which are provided for in the regulation. In the Principal Act, you had only 7 categories of persons that were entitled to apply, and those were an employer who will then submit an application to check whether the employee that they've got in their employ is listed in the National Register for Sex Offenders or not. Then you will have a licensing authority in respect of an application of someone who seeks to apply for a license, let's say, for example, for someone who wants to open a crèche or any facility that will be taking care of children in that space. Then a relevant authority in respect of an applicant who is contemplated in terms of section 48(1). Those you will have the courts who are actually determining any other case in the children's courts. You will have a government department that is applying in respect of its employees. In this space, maybe we will say teachers or the Department of Social Development, and those ones that have those employees that work with children in their day-to-day functions. And you will have an employee who will then approach us in his or her own right. And you have a person who then applies for a license or approval to manage or operate any entity business concern or trade in relation to the supervision over or care of children or persons who are with mental disabilities. And this one is the one now who applies in respect of his or her own particulars. And now 48.2 applies to become a foster parent, kingship caregiver, temporary safe caregiver, an adoptive parent in respect of whom again, his or her own particulars. And then you will have on the last one, any person whose particulars appear. You know that you have been convicted of committing a sexual offense and you want to ascertain whether or not realistically when the magistrate said, I am making an order that is convicting you of committing a sexual offense against the child, indeed they did send your details to the National Register for Sex Offenders or not. Then, now I want us to look into the obligations of the employers in respect of their employees. So any employer who at the commencement of this chapter, which was the 30th of June 2009, who has in his or her employment any employee may from the date of establishment of the register in the prescribed manner by way of that application form, apply to the registrar for what? A certificate, which does what? States your employee has got a previous conviction and as a result is listed in the National Register or not. Then it also says from the date of establishment of the register, if you intend employing someone, these are potential employees. You must also apply for a prescribed certificate wherein it states the potential employee that you want to employ does not have any previous sexual offenses conviction against their name. So if you are an employer and you have any employee that has a previous conviction, it says, subject to paragraph D, you will not continue to employ that employee whose particulars are recorded in the register. In D, you will see it will tell you exactly if you have such, what you must do. So an employer who, during the course of employment, you then ascertain that particulars of this employee has been recorded in the register, irrespective of whether such offense was committed during the course when he was employed by you or before you could have actually employed them. You must do what now? This is what D says. Immediately terminate the employment of such employee. I know that in the meetings that I've had with DBE mostly, with social development, you will find where they will want to find out whether or not it will be legal. You know, are you covered in terms of the law to dismiss employee? My answer has been, and my answer is, yes, you are covered, because that's where it is stipulated that you will immediately terminate the employment of such employee, because this then now takes you to the objective of why the National Register for Sex Offenders was implemented in the first place, is to ensure that each and every person that has a previous conviction for a sexual offense against the child or anyone with mental disabilities cannot continue to be employed in that space. In some section here under it says you can try to remove that particular person and place them where they will not work with children, but in a school's environment, where else can you move such a teacher? Because the primary objective of the Act is to ensure that anyone that has a previous conviction or a sexual offense conviction against their name does not continue to access children in that manner. So this is where C says, notwithstanding paragraph D, an employer must immediately terminate the employment of an employee who fails to disclose a conviction of a sexual offense that they have against those two categories of persons, or anyone who has been convicted in terms of Section 77 or 78 of the Criminal Procedure Act. These are the state's patients as we know them. A person who was unable to stand trial, but who has been convicted in terms of the Criminal Procedure Act and who actually was transferred to any mental institution to go and serve their sentence from there. But now this is the red part, an employer who fails to comply. Those employers have always asked me, if we don't do that, if you fail to comply with the provisions of this section, you are guilty of an offense and are liable on conviction to a fine or to imprisonment for a period not exceeding 7 years, or to both a fine and such imprisonment. Then we look into the obligations of the employees. The obligations of the employees, if you see them, they are a flip side of what we have seen with the obligations of the employer. This is now placing an obligation on you as an employee, that if you are in the employ of an employer at the commencement of this chapter, and you know that you were convicted of a sexual offense against those two categories of persons, irrespective of whether or not you have committed that before or during the course of your employment. And if you know that you've got a sexual offense, you must, without delay, disclose such conviction binding to your employer. So this also goes to say, if you have done that after the commencement of the act, you still have that obligation to disclose such conviction or finding when you are applying for employment. An employee who fails to comply is guilty of an offense and is liable on conviction to a fine or to imprisonment not exceeding 7 years, or to both a fine and such imprisonment. So you will note, colleagues, that even if an employee comes to you and disclose, you as an employer must take reasonable steps to do what? Remove them from accessing the children accordingly. Now, we will actually deal with the new Amendment Act. The amended criminal law still outlaws exploitation and sexual grooming of children and persons with mental disabilities. It provides now that perpetrators of any sexual offense against, now the dispensation has changed to having a focus on children and vulnerable and children and mentally disabled, to say now vulnerable persons. This now then outlines to you that the Amendment Act has increased the scope of what we see now as provided in the National Register for Sex Offenders. So it no longer requires that only children and mental disabilities. It has added another category of vulnerable persons, that anyone who's found guilty of committing a sexual offense against a vulnerable person, their details must be included in the National Register for Sex Offenders. So this is why Parliament responded to calls to tighten up the management of the Nrso. So those who were initially convicted of committing a sexual offense and who were actually sentenced to less than 18 months. At the previous dispensation, they would only stay in the register for 10 years, but now this particular time frame has been increased to say they can only apply to have their names removed from the Nrso after 20 years has lapsed. So this has brought about those doubling of timeframes, especially where you find that a person was convicted to a sexual offense to something that is less than 6 months. That person was supposed to stay in the register for 5 years. Now they stay for 10 years. Those who were convicted to or sentenced to more than 6 months, but just less than 18 months, like between 6 and 12 months, thereabout. They were supposed to stay in the register for 7 years before they can only apply for removal of their details from the register. Now, that period has been doubled to 14 years. Similarly, with those that were to stay 10 years, now it's doubled to 20 years. This is the basis upon which you see that sentence now stating that those who have been sentenced to a period not exceeding 18 months, they will then have to qualify to have their details removed from the register after 20 years has lapsed. So the amendments to the 207 Act, they aimed to extend the ambit of the offense of incest so as to provide additional protection now to children, because the definition of incest in the Principal Act, in the 2007 Act, it was just laissez-faire in its nature. But now it has gone to state that if you are an adult in that incestuous relationship and you should have known better that what you are doing is wrong, then you, in or when you are to be convicted, you will be convicted the same as the hardcore sexual offender will be convicted. Like if you ought to have known better as an adult person, this, which is why it said so as to provide additional protection to children. It is now specific in terms of who it seeks to protect. So it has also introduced a new sexual offense, an offense of sexual intimidation, to protect persons from threats of imminent sexual harm. If you actually do feel that whatever the next person utters to you constitutes an imminent sexual harm, you must report such to the police, and then the police must investigate, and upon investigation, if a conviction then is secured, you will be charged, convicted, and sentenced like a hardcore sex offender, even from uttering a word, a silly word, which the next person will then perceive as a threat of imminent sexual harm. 6.3, it says it substitutes where a person who is mentally disabled appears. We have substituted that with persons or a person with mental disabilities, because we did not know better. Our act has always been referring to persons with mental disabilities as persons who are mentally disabled, but wherever the phrase appears, it's persons with mental disabilities. It has further regulated the inclusion of particulars of persons in the Nrso. This now is the one that states that we no longer focus on those that have violated children or vulnerable persons. We are saying every other sex offender, irrespective of who you have sexually violated, their details are going to be included in the National Register for Sex Offenders. So every sex offender now will be included in the National Register for Sex Offenders, irrespective of who the victim is. Nice and simple. It has extended the list of persons who are to be protected in terms of Chapter 6. Remember when I started, I said it protects children, it protects persons with mental disabilities. Now, it has included a category which has said that the dispensation has changed. It has included now vulnerable persons, and those vulnerable persons are children and persons with mental disabilities still stays. But now, any female who is under the age of 25 years, who receives tuition at a higher education college or higher education institution or university college as defined in terms of Section 1 of the Higher Education Act of 1997, and who receives vocational training at any training institute other than the institutions which are referred into paragraph 1 above as part of their employment. In this instance, you will have those that are serving internship in different departments, in different government departments. Or this person who lives in a building, a structure or facility which is used primarily as a residence for any of the persons that are referred to above, or a person who is being cared for or sheltered in that facility that provides services to victims of crime. Number D, it's now over and above to a person with mental disabilities. It has included persons with physical, intellectual, or sensory disability, and who receive community-based care and support services other than from a family member, or who lives in a building or structure or facility which is used primarily as a residence for those people, and is cared for in a facility that provides 24-hour care to persons with physical, intellectual, or sensory disabilities, or any person who is 60 years of age or older, and them who also receives community-based care and support services, who lives in a building or structure or facility used as a residence, or is cared for in a facility that provides 24-hour care to such persons. And on 6.6, it says it extends the list of persons who are entitled to submit applications to the register. You will recall I mentioned 7 categories of persons. Now it has added the 8th one to say any person who seeks to find out whether or not the details of another person are included in the register. We have also included that category of any person that may want to view whether or not the details of another person, it's a neighbor, a boyfriend, or whoever, that you want to check whether their details are listed in the register. We have extended that to say any person can do that. However, there's a catch. If you are that any person, you must ensure that when you apply for same, you are sure that that is done in the interest of a vulnerable person. And that your application that you are submitting, it is not done in a vexatious or a frivolous manner. Otherwise, that is the basis upon which your application can be rejected. Now on 6.7, it says it further regulate the removal of particulars of persons from the register. This is what I've outlined in terms of those time frames. 5 years doubled to 10 years, 7 years doubled to 14, 10 doubled to 20. So that's basically that. It now further regulates the reporting duty of persons who are aware that a sexual offense has been committed against the person who's vulnerable or not. Like I said, at first, the Principal Act says, if you've got, based on your awareness, if you're aware that a sexual offense is being committed against a child or person who's mental, report such to the police. It did not have what then happens if you don't report. Now, this amendment has come up with saying if you don't report, it's a criminal offense, and if found guilty, you can be fined or be given both a fine and a prison sentence. And then this one has added a reasonable suspicion, because at first you will then act on the basis of being aware. Now, even if you've got a reasonable suspicion or a flicker of a doubt that something is happening somewhere, you can take that reasonable suspicion, report same to the police, and the police must actually investigate accordingly. Oh, I am done. Thank you, Chairperson. I am done, and thank you so much for the most attentive audience. I will hand over back to questions or comments, if any.
Thank you, Ms. Makila. Ms. Makila, for those who have joined us before we started the the introduction. She is the registrar for sex offenders, and the very first in the country. And now we are opening the platform for questions. I would like just to check. I don't know what is happening there. What is happening there, Rwando? Is there anyone who has tampered with, or can I just ask you to stop the presentation? Is Makila? Yes, good. Yeah, thank you. Now, yes. Yeah. All right. Now we are getting to the questions and answers time. If you have any questions, then you can raise your hand. We will be recognizing you. And I would also like just to check from the chat if there are any questions. All right, people are asking for the presentation. And also then your audio, I think it was. So the presentation will definitely be made available to everyone who is here, who has given us your email address. So you can just reflect your email address on the chat, and we will send you the presentation. A number of issues have been raised during this presentation, which are very, very, very critical. Issues of the, if you are registered, you may lose your employment. If you have been, you are registered in the register for sex offenders. It's a number of issues that have been raised here. And the fact that now even people who are providing services to older persons and certain categories of persons who have disabilities, then you have to be registered, and it is an offense if you continue providing those services without having been vetted. So you must get a certificate that will be issued by Ms. Makila to the effect that you are cleared from the register, so you can continue providing those services. So let me just, all right, so we will start with Abraham, and then we will get to 34246472470. That's going to be the second one. All right, in that order. Thank you.
Mute.
Yes. Abraham, your reaction, please. If you can unmute. Abraham. Abraham. Yes, you have unmuted. Let's have your question or your reaction. Thank you.
Am I audible enough?
Yes, you are.
Okay. Once again, good afternoon, colleagues. I'm Abraham Nguni. I'm the founder and CEO of Positive Flame South Africa, which is a non-profit organization that is leading 372 organizations that are working at the grassroots level. My concern is the how part in terms of the getting the compliance certificates to say employee so and so is vetted and they have no convictions. I'm looking into the how part as to how do we then access the registrar, because somehow she did not allude to the point of how do we then get into that system to say how do we then get these people vetted, including ourselves, because you might never know. I can be an employer and still be convicted. Thanks.
All right, thank you. Let's get now to 38246472470. and it will be followed by Fatima in that order. Thank you. Fatima, would you please, I don't know whether we have a situation. Fatima, I'm giving you the opportunity to ask your question or give us your reaction. Thank you.
Hi, it's good afternoon. Can you hear me?
Loud and clear. Thank you.
Right. Good afternoon, ladies and gentlemen. It's Fatima from the Department of Social Development, responsible for appointing learners, interns, and your student social workers. So my question also would be, how do we do it? I appoint them annually. They are exposed to our children in our institutions, especially your child and youth care learners and your social auxiliary worker learners. How would I be able to do it? Do I submit a form with all their names? Or is there a specific form that we need to fill in per student? And number two, the cost for the department. Would it cost anything for the vetting process? Thank you.
Thank you, Fatima. And I would also like to add that what are the documents that you are supposed to be submitting to have yourself cleared? I think that would be the follow-up question. Joseph, I'm recognizing your hand.
Thank you. Good afternoon, colleagues. My question is, what now happens with the existing cases, the cases that are on the roll, where I'm supposed to be acting as an intermediary, and I'm not yet vetted, I'm not yet having a certificate, like I'm having a case on the 16th next week, Friday. What's going to happen there?
Thank you. Let me also just go back then to 382464, and the rest of the numbers that are there. We're giving you an opportunity because you raised your hand first, so I wouldn't like us to miss your question or your reaction to this presentation. Would you please mute yourself and so that we can get your response or your reaction? 3824. Just mute yourself, please. All right, then, Ms. Makila, would you please respond to these questions? Thank you.
Yes, Chair. I would also, in response, if I can be given just a few minutes to share the checklists, which will be in response of what the two speakers have raised. And let me also deal with the one that the last speaker has raised as well. I'm not sure whether you have submitted your application to be vetted against the register. If you haven't done so, I'm going to share the checklist, and then you can ensure that you submit same to us, and then we can issue that certificate to you as soon as we possibly can. Sometimes it even takes to, a few hours, a few minutes. If we receive all the required documents now, I'm going to share what documents are required for what certificate. I'll be quick. Is it appearing? These are the checklists. Yeah, these are the checklists that we have also published on our departmental website in terms of each and every requirement that we might have. These are the checklist for someone, let's say, for example, who is applying for a certificate in respect of their own particulars. Let's say, for example, you ask your own employees to go and get the certificate from us. Then they will have to fill in a form which we call is a J738 or a Form 7. So the following documents that we require It's that completed and signed J738 form or a Form 7. And then at the bottom, you will see it requires that a person must fill in the reasons why they're applying for a certificate. Then you will say employment or vetting purposes or whatever reason, or adoption purposes, whichever reason that applies to you. And you must ensure that you have signed that particular J738. Then we require from you a certified copy of an ID document or passport. And here you must attach a fingerprint report. A fingerprint report is the report that is obtainable from the SAPS police station, any SAPS police station. Let's say, for example, you take your 10-piece where they take them on ink. You must explain to the police that I am doing the 10p because I need to obtain a fingerprint report. A fingerprint report is important how to us. It actually articulates whether or not you've got an awaiting trial case or an awaiting sexual offences trial case that has been preferred against you. This will then answer whether or not you've got a pending case against you, or you have been investigated and now are charged with another sexual offense, to which, if that is the case, we stay that application until such time we receive a final outcome. Then we can proceed with a yay or nay certificate in terms of your case. So you must also provide a full forwarding or address wherein we can send that certificate back to you. Another one is for a person. No, this is the one where a person is applying for removal. Yeah, this is the one where an employer can now apply for a certificate to determine whether the particulars of another person are listed in the National Register for Sex Offenders. This is the J739 form, or a Form 8. So a Form 8 and a Form 8A, they are actually different. This is the 8A, but let me share with you the 739. Yes, this is a Form 8. A Form 8, although it's slightly the same with a Form 7, the only difference is that you as an employer, you now become an applicant. So you must ensure that page 2 is fully completed. Page 2 is the one that contains the details of the person that you are submitting, on whose behalf you are submitting this application. Let's say, for example, your employee. You must attach the certified copies of an ID document of that employee. You must also attach a fingerprint report, and then you must also provide a full forwarding address, your full forwarding address. On this one, okay, now there was the issue of the cost. The certificates from the Department of Justice are issued free of charge. But for you, in order to obtain a fingerprint report, it means you must pay, I think it's 170 or something thereabout. But for us, the certificate is obtainable free of charge. And then we've got a Form 8A. A Form 8A is a completely new form. This is the one which is utilized by any person who actually seeks to find out whether or not the details of another person are included. Here, you will see it looks different to the Form 8, which an employer fills in. This one, a person who actually applies to check if the person the details of another person appear, they must complete the Form 8A and sign it accordingly. And this application form, you will see it is in the form of a sworn affidavit and must be completed by the applicant. So the applicant becomes who? The person who applies to seek whether their next door neighbor is there. You have to also attach a certified copy of who? Your next door neighbor. You must attach a certified copy of an ID. I think this is repetitious 3 and 4. You must attach a fingerprint report of who? Your next door neighbor. You must, and a person on whose behalf an application is submitted must also give consent in writing that I approve that, okay, fine, my neighbor can go and check on my behalf, because you will recall that we also have POPIA, which actually protects the disclosure of the personal information of another person. So we have to actually ascertain that you are not doing this clandestinely. And afterwards, you must give a full forwarding address, and then we will respond accordingly. So I believe that I've answered all the questions.
Thank you, Ms. Makila. All right, now from the chat, we have Mr. Tefo. He says that I have been requested, actually ordered by my employer to run my name on the Nrso, but I have never received the clearance certificate. Isn't there any other way of accessing the certificate, like self-service, like platform? If not, would it be a good idea? Thank you. If you can just respond to this question. And it also comes with a suggestion. You know, I know that the department has developed the online application solution. If you can also mention that. Thank you.
Okay, thanks, Chair. Yeah, the online solution is there. However, we are still on the pilot phase. We haven't opened it up yet. I think that is going to be a solution wherein you can apply online and then we can respond online. So following the department being hit by the malware, we have not yet fully recovered from that, which is why even our online portal has not yet been open to the general public, but we are still on the pilot phases of that online portal. So as soon as we are ready to go, because I heard that we are also going on a scanning solution, which is part of the online solution, because when you apply through online, you also have to append those documents or scanning them through so that we can be able to deal with your application there. So we are still piloting with only 2 institutions, which is Curo and SACE, the South African Council of Educators, but it's not yet there. And like I'm saying, it is still on pilot phases. We are piloting that. As soon as we are able or have opened that to the general public, we will announce that accordingly. But for now, unfortunately, it is a manual process wherein you have to fill in the forms, attach a fingerprint report, and forward that through to us. And then we can process that as soon as possible and send the certificate to you. So indeed, when your employer has instructed you to come with a certificate, you must apply. So I'm not aware if you have submitted your application accordingly. If you have, you can give me your details and I'll go and check how far we are with your certificate, whether or not was in the bulk of the certificate that we have issued recently. Thank you.
I think Mr. Tefo, what would work will be the name that you have used when you were doing your application, as well as your email address, so that you can get then the response from Ms. Makila, because she's the person who's actually issuing these certificates. Now, there's another question that is coming through. And I would also like to let people know that in terms of the Act, the Act sets a turnaround time of 10 working days. All right. So this is one area where she cannot default in terms of time. When you get your application and it has all the requirements as she has stated, then the law requires her, to respond within 10 working days. All right. So there's another question that is coming from Priscilla. It says, what is the turnaround time for submitted employee applications made at the NRSO? That's the question. Okay. Would you please open your
Oh, my mic, sorry. It's 10 working days. When you submit today, like what the chair has said, we are obligated to issue those certificates in 10 days.
All right. Now, there is also another question. I think, let me just get to the hands now. All right, Irene.
Good
I'm
afternoon,
recognizing your
colleagues.
hand.
Good afternoon, colleagues. Thank you very much for the presentation. It was very informative. My name is Irene Rafferty. I'm working for Department of Social Development in NPO partnership, which means we work with NPOs. We monitor NPOs. I would like to know, some of our NPOs had, through our statutory unit, submit their documents, but we have not received feedback in that regard. That is the one thing. So linked to that, I would like to know if the registrar is fully capacitated to deal with all the applications, because as we have this session now, it means more applications will be submitted. And then if there's any backlogs and how we would work from there. Thank you very much.
I have provided my email on the chat box for you to forward me the list of applications, the date which you have submitted them, and then we'll make a follow-up and ensure that we have dealt with that. Because we, on a daily basis, we receive a lot of applications, so it is quite difficult to actually see which ones are from where. And then as and when we receive those, we do send that through. Yes, we are now getting capacity. We have advertised some positions on DPSA in the last 2 weeks, and I think they've just closed last week, Friday. And we have also increased our capacity also to the directors legally in all 9 provinces. So we are busy setting up on the system. They are getting registered and they should be in a position to do what I'm doing and issuing out the certificates that are coming from, all the provinces in the 9 provinces throughout the country. So capacity-wise, there is some change that is slowly coming in. Thank you.
Thanks, Ntombi. I think this is going to bring us to an end. I'm not sure if there are any other questions that I have left out. This Act is actually the Amendment Act, as she has said, that it has expanded the spectrum of people who must apply for vetting, including your nannies at home, your babysitters, the early childhood development practitioners, child and youth care center, youth care workers are also expected then to be vetted, and the social workers as well, intermediaries, as I have said, including the ad hoc intermediaries, because now we have the Criminal and Related Matters Amendment Act of 2021 that recognizes expressly recognizes the services of the ad hoc intermediaries. So before you can actually provide your intermediary services, you must be vetted against the Nrso. And also, I think the lecturers must be vetted, the workers in those institutions of higher education must also be vetted. And also the shelters, people who are providing as support services in shelters, white doors must be vetted, and workers in retirement villages and those who are providing services in older persons service facilities must be vetted, including the pastors or workers who are providing services, in child youth departments in churches must be vetted. And it includes a number of people that I have not mentioned right now who must be vetted, who are exposed to persons, vulnerable persons. So it's a lot of people. So with us, if you are the mother and you are you've got a nanny at home, you have to have your nanny vetted, all right? And a failure to do that will amount to a crime. And so this is actually the gospel that we need to spread, all right? So now I'm going to give then, in the absence of hands and comments, I am going to give the Nrso an opportunity. Oh, I think there are other questions, all right? Okay, I did not see them. All right, so this one is coming. Let me just go up. But this is Fitliwe. Fitliwe says that, good day. There were talks that the Department of Justice will publish the name of the offenders after they have been prosecuted. I believe that means convicted. Is there still such a consideration? Most of the community are unaware of such processes, especially families of victims. When the convicted person is released and is now part of the community. Also, will there be awareness programs in most marginalized communities to educate them as you find people volunteering their services, especially at schools, etc. All right. And then the other one is coming from Ndlovu. Ndlovu says that there are court intermediaries who did not as yet receive their certificates. Only few did. Must they reapply or await to check if they might have been issued as per the checklist? Then this other question is coming from Advocate Velna Lemley. Magistrates and prosecutors are vetted. Attorneys and advocates, especially those in private practice, wants to know if they must be vetted, all right? And yeah, I think those are the questions. Over to you, Dombi.
Okay, thanks, Chair. With regard to the first one, I have attempted to answer it on the chart. We will not be publishing their names, as that will be.
Okay, we are losing your audio.
Against.
Okay, we have lost you. We lost your audio. Okay, maybe if you can switch off your camera. Okay, Miss Makila, we lost you, all right? So I'm requesting that maybe if you can just switch off your camera so that it can enhance your audio functionality and quality.
I'm back. Okay. Am I audible?
Yes, you are now. Thank you.
Okay, perfect. Yeah, based on the first question, that whether or not we will be publishing the details. No, that has not been approved as part of the amendments that we were doing, as that is against the law. Remember, when we convict someone of committing a sexual offense, the considerations that were given is that over and above you convicting them, you are giving them a second conviction in putting them into the register. So when we publish the names, we will not, or that particular action will not pass the constitutional muster, in that you are violating a few pieces of legislation which are inclusive of the Constitution itself, the right to privacy, as well as the Promotion of Personal Information Act, because before you can start telling someone that somebody did this, you need them to give consent to that. But the long and short of it is that that is unlawful. We are not going to publish them. And yes, we are trying our best to do all the awareness campaigns through the marginalized, through radio, through all these other forums. Because last again, we were also part of the webinar that was done by the TPN Credit Bureau, the one that actually was published also on the group, stating that there are teachers that are actually who have, you know, the general criminal records and stuff like that. So we are trying our best to be everywhere and say everything else about what the register provides and stuff like that. On the second question, on the vetting of intermediaries, I've shared my emails there. Those intermediaries who have not yet received their certificates, because we are also encountering some problems when we are sending back the certificates. When we call the people based on the numbers that they've provided us on the applications, some of them go unanswered, some of them, you know, because when we actually want to send it per email and arrange for you to get it via courier or something else, most of the people never answer their cell phone. So you will find that we have issued that a long time ago. However, the applicants have not yet received them. And on another question again, whether or not the magistrates, the prosecutors, the attorneys and advocates have applied. The prosecutors, yes, we have vetted them, but the magistrates, although we have written to the Magistrates Commission, I still yet to see an application for a certificate that seeks to check whether or not one of the magistrates are listed in the register. So we haven't received that from the judiciary. Some of the private attorneys, yes, do submit. Some of the private advocates do take that, but it's not that much frequent, I must say. So we need obviously to get out there to, you know, preach much on what the Nrso entails. I'm not sure if I've answered all the questions or I have missed maybe the last one, I think.
All right. Hey, we seem to be losing your audio, but then it's just when you were ending your responses, so don't worry. Now, there is another question that is coming from Faith. Faith wants to know, is the registration the sole responsibility of the employer or the supervisor who has the officials reporting to her or him?
The employer, the supervisor can do that because it is your obligation to see to it that people that report under you or work under you in any way, manner or form, they have got those. I can say there are supervisors that represent employers in that space.
Okay. All right. So, but it's not their sole responsibility. Also, you as an employee, you must
Yes.
yes, apply.
You must disclose. Yes.
Yes. And now coming to the practitioners of the Legal Aid South Africa, they need to submit their applications. Those who are providing services in terms of the exposed to children who require representation and so on, and also the older persons, all those categories, that fall within those persons who fall within the category of vulnerable persons. All right, so they will need then to submit their applications. All right. So this is just one of the ways of us reaching out to people to let them know that there are changes that have been done in terms of this act. So you must have your people registered. Your people vetted, and also have yourself vetted if you are providing services that give you the direct access to vulnerable persons. So I think then this is just taking us to, there are no further questions. Let me see. Okay. All right. All right. So there are requests then here for the presentations to be submitted. But there's also one question that is coming from Tabiseng. Tabiseng wants to know, he says, good afternoon. Do the certificate expire? A brilliant question, Tabiseng. And I think it is also, that is in Tabiseng. And Espino is also coming with another question here. What is the duration of the validity of the certificate? Does it expire? It's a similar question. Oh, the same question.
Okay. Yes, the certificate does not have a validity time frame. However, we have included there on the notes to say the certificate is valid as of date of issue. So meaning that the employer can, as and when they want to submit a fresh application for an employee, they are welcome to do so, because the silence on what we see on legislation, I think it was deliberate, because you can issue a certificate today, and tomorrow, if you say, let's say, for example, the validity period of a certificate is 2 years or it's 6 months, and tomorrow that particular person can go and have a sexual offense, and they will continue, producing that certificate over and over. But if you see that note in fine print at the bottom, the validity of the certificate, or the certificate is valid as of date of issue. It actually requires you to, as and when you want to submit a fresh application, you can do so. And then we can do a fresh check.
It will need a further amendment there, because what happens then if a person commits a sex crime and is convicted thereof, after,
Exactly.
so it's one area, it's a lacuna that is in the act that needs to be addressed. All right, so I think this is taking us to the end of the session. Your parting shot?
Yeah, my parting shot is, I would like to urge, all those that are on the platform to actually, go and talk about the importance of the register, because I was shocked just the other day when someone was downstairs who had applied to have his. When I issued out the certificate to have him check whether or not he's going to be removed, I found out that this guy is not going to be removed. However, he said, please issue out my certificate before 12, because I need to go and fetch the children. I got a shock of my life because seeing that this person is actually transporting children to and from the schools. This is where you will see that many people are not even aware of the importance of having anyone that accesses their children have the certificate, how important it is, because you can see even this guy was actually like saying, give me my certificate, I'm going to fetch the children, even if he was not getting out of the register. So you can see how rife this thing is. And we need to ensure that those people never, ever, ever access the children in any way, manner, or form. Thank you, Chair.
It's a lot of responsibility also on the parents, all right? As a parent, to check if your teacher has been vetted, the driver who's transporting your children to school has been vetted, your nanny has been vetted, and the teacher of the swimming classes and so on have been vetted. It's a lot. It's a lot of responsibility on the parents to ensure that all of these people that are exposed, are providing services to your children, are actually vetted in terms of the vetted against the Nrso. So we need to take up that responsibility and check. All right. So I think that is then bringing us to the end of the session. Thank you so much, Ms. Makila, for such an informative session. And I'm hoping that it is not the last. We'll be coming back to sort of simplify all these amendments that have been done. And what is it that we are expected to do as parents, as employers, as employees that are placed at service points that expose us not only to children, but to persons, vulnerable persons, meaning that the older persons who are in those institutions where they are receiving the support services, persons with mental disability, sensory disability, physical disability, intellectual disability, and also those young women who are in tertiary institutions and so on. The Act says that if you are providing services, including children, of course, if you are providing services at those service points, you are then required to have yourself vetted against the Nrso, and the failure to do so as an employer or the person who is responsible for those areas, then you are committing a crime. And this is not only limited to people who are who are outside government institutions and departments. Also, as a DG, as a head of an institution, if you have your people there that are not registered, you are committing a crime. I will make an example as coming to DBE and also to the Department of Health. If you have your nurses there and your doctors that are providing these services to children and are not only to children, to all vulnerable persons, and they are not vetted, you are actually committing a crime, irrespective of whether you are a government employee or not. All right. So this is quite serious. It's quite serious. So we need to roll up our sleeves and people who are here and inform those who are at those service points of this information. So the presentation will be made available. The only thing that you are requested to do is just to drop in your email address here so that you can get the presentation. And it's not only you getting the presentation, you will also be alerted of other webinars that are upcoming. So Luando would you just advise us of the next webinar that we'll be having? Luando?
Oh, okay. Thank you so much, ma'am. We are having a webinar on Tuesday. Specifically, it will be focusing on child maintenance. I'll send over the invitation. If you can just, all of you guys who would like to participate in that webinar, just write your email address on the chat box so that I can actually send the invitation and also the presentation that Ms. Machila has done. And then from there, I will keep on updating and inviting you to other coming webinars, as Advocate Kambula has said. Thank you.
Thanks, Lwando. And I would also like to say that this presentation is also going to be uploaded on our YouTube for the Department of Justice. So keep on, checking its availability. It's gonna be there, I think, in a few days' time. Thank you so much. So this brings us to an end of this session, and thank you for being such a wonderful audience. We had very limited, disturbances. So we really thank you so much. So goodbye.
Thank you.
See you at the
Bye.
next webinar. Thank you.
Thank you. Bye.
Thank you. Bye-bye.